May I please, Lordship?
Yes.
My Lord, I beg to mention hearing item number 37 on behalf of Indian Song, my Lord. Kindly list the matter after next week, my Lord. Next week.
Very pleased, Lord. This item 37. Last time, the appellant has made a mention that they are likely to withdraw the case. So 3 weeks time was given to them.
Correct.
Now, till date, no information has been received.
Okay.
And I believe they are playing with this game. So, Your Lordship, let it be disposed of, since today may not be possible, next week. Either way, let it be disposed of. If they don't withdraw by next week. Next week, let
Yes.
it be disposed of.
Okay, we'll actually grant 2 weeks time. Within
Correct.
that, if there's no development, then we can take up for, take
Yes.
up the.
And your lordship, make it sure that no further adjournment. Because we are facing a lot of problems.
Okay, okay. Okay. On the prayer of the learned government advocate. Listed after 2 weeks. Stop. It is made clear that an endeavor shall be made to dispose of the case on the next date. That is on
15.
to dispose of the case on 15/11/2023.
Yes. Lordship.
Okay,
Oblige, your lordship.
Much obliged.
this is item 20,
37.
item 37, okay.
May I please, Lordship? My lord, I pick the mention item number 2.
Item number,
2. That matter will come up after 2 weeks, my lord.
Mr. Nguli,
Yes, my lord.
you were repeatedly asking for adjournment.
Yes, my lord.
If you don't want to prosecute the matter, close it. Why keep the matter piling up? On the prayer of Mr. Zatan Muli, the learned counsel for the appellant, listed after 2 weeks. Okay,
Mas-
May I please, your lordships?
yes,
I beg to mention hearing item 24 to 32. I plead this matter may be listed after 2 weeks.
24 to
32.
24. You're the counsel for the,
Respondent.
who is the petitioner?
I'm
The
for the
state,
appellant, my
okay.
lord, yes.
On the prayer of Mr. So-and-so, the learned counsel for the respondent, listed after 2 weeks. Okay, yes,
Obliged. May I please, your lordship?
yes,
I beg to mention item number 12. Here I've received instruction, kindly allow me 2 weeks time to file affidavit, madam.
My lord, if this can be fixed on 15th of November, because the leading counsel is an outstation lawyer, so she will come
okay.
for hearing.
You filed it before 15?
Okay.
On the prayer of the learned counsel for the parties, listed on 15/11/2023. Okay,
Much obliged.
May I please, your lordship?
yes,
My lord, I may be allowed to mention item number 9, 10, and 11. My lord, if I may be allowed a week's time, affidavit in reply is almost ready, so I will file it within a week.
Mr. Takakichu, the learned counsel for the petitioner, 6 for 2 weeks time to file affidavit in opposition. On behalf of
My lord, on behalf of
the affidavit in reply,
Yes, my lord.
prayer is allowed, listed accordingly. Okay,
Obliged, my lord.
Much obliged.
Your lordships, I
Yes.
beg to mention hearing item number 33 and 34 on behalf of Victor Soccer.
33 and 34.
Yes, I pray that it may be listed after 2 weeks.
33,
I have no objections, my lord.
okay. On the prayer of the learned government advocate, listed after 2 weeks.
Obliged, my lord.
Obliged.
May I please, your lordship?
Yes,
I beg to mention item number 23. Your lordship, kindly the matter to be adjourned for another 2 weeks.
you're for
I'm for the petitioner.
petitioner. Your good name?
Prenyo.
MS so-and-so. Makes a mention on behalf of MS Santila, the learned counsel for the petitioner, and seeks adjournment of the case for 2 weeks. Prayer is allowed, listed accordingly. Okay,
Much obliged, your lordship.
Please, your lordships.
Yes,
Item 13, your lordship. May I pray-
Item?
13,
13-1 for
your lordship. May I pray this matter be listed after 2 weeks? I'm yet to file my affidavit, your lordship.
S. Mary. The Learned Senior Government Advocate. 6 for 2 weeks' time. To file affidavit on behalf of the state respondents. Prayer is allowed, listed accordingly.
I'm obliged.
Anything, Mr. Joshua? After
Yes,
2 weeks.
2 weeks.
2 weeks.
Lordship, this being a petition which deals with Article 21, let this be the last opportunity, Lordship.
Lordship.
They say the Learned Government Advocate shall make an endeavor to file the affidavit on or before the next date fixed.
Lordship.
Bless you, Lordships.
Please, lordships.
Yes, please.
My lords, I beg to mention item number 22.
20
May it come up after 2 weeks, lordship.
item
22.
20. It is with 21.
Yes, my.
It is with 21.
Yes, lordship.
And you are the counsel for the,
For 22.
no, you are the counsel for the,
For the appellant in item number 22, lordship. We have the consent from both the parties.
what about 21?
My lord, I'm agreeing.
Okay. On the prayer of Mr. K.R. Kha,
Yes, lordship.
K.R. Kha,
K.R. Kachuk.
the learned counsel for the appellant in CRLA J4/2020. The matter is adjourned for 2 weeks. Okay,
Much obliged, lordship.
May I please, my lords?
Yes.
Lordship, item number 18 and 18, 19 and 20, lordship. May be listed after 2 weeks, lord.
over. Mr. Kiangami, the learned senior government advocate, the learned PP, correct?
Lordship.
6 adjournment of the case for 2 weeks. Prayer is allowed, listed accordingly.
Bless you, lordship. Lordship, then item number 7, lordship.
Items. Yes,
Lordship, today I have difficulty, so maybe listed next week, lordship. If it is
No objections, my lord.
item 7.
Lordship.
On the prayer of Mr. Kiangami, the learned PP, listed after a week.
Bless you, lordship.
Much obliged.
Okay.
Lordships, I beg to mention item number 4, 4, 5, and 8. On behalf of.
One by one.
Sorry,
Item,
4,
what is your prayer?
for 2 weeks, my lord. On behalf of B. Socrates.
The item 4, the learned government advocate. 6 for 2 weeks' time.
Yes.
6 adjournment of the case for 2 weeks. Prayer is allowed? For what? Adjournment for what?
We are yet to, we just received a copy of the status of the school. So, in the petitioners.
What is the matter, ma'am?
The matter is about two government middle schools in Mon, lordships. So we have given a letter status of the schools. So,
By the last order, they were asked to file affidavit, something.
no,
of
your
that?
lordship.
Ah.
Lord, in fact, we saw time and then we have filed accordingly last month.
Okay,
So, due to the council, Madam Chokre was there, but then since she was not there on the last occasion, we could only furnish today, your lordships.
okay.
That is the case.
Okay. Okay, item 4, on the prayer of the learned government advocate. List the case after 2 weeks. Then item
5, lordship.
same,
Yes.
same case, ma'am. Item 5, okay, same. Then
And item 8.
same,
Yes, your lordship.
item 8.
My lord, here in item number 8, there is an interim, so it may be allowed to continue.
8, item 8, same order. In addition, the interim order passed earlier shall continue till the next returnable date. Okay?
Much obliged.
Lordships, also on behalf of LT Sanctum, item number 3. If it could be listed after 2 weeks.
Why all the additional ages are always absent? I see that.
My
So
lord,
within-
the Additionally, AG is getting married today.
Oh. LT Sanctum?
Yes, my lord. At Kohima.
Okay. Okay.
So if we can
Item-
come up with
item-
1 week, my lord. Item
Ah.
3.
Item 3, give him at least some time. Item 3. On the prayer of the learned government advocate, listed after 2 weeks.
Obliged. Much obliged.
Who, you are appearing for?
For the Union of India.
And who is now appearing? Who is appearing now?
Can you see the
Oh.
in all the cases where more is involved, they have engaged.
Let for some time. You have written the letter, they have engaged you, you have written the letter. There is still no reply. So let us wait for some time. Let's see the next date. Okay? Yes, I'll give this back.
May I please, your lordships,
Yes,
I beg to mention item number 1. On behalf,
item 1.
yes, your lordship,
Ah,
on behalf of Mr. Pakin Richabo. Here, affidavit in opposition is yet to be filed.
what is yet to be filed?
Affidavit in opposition. So I plead 2 weeks time may be granted.
Yes,
My lordship, last time also they take adjournment for filing affidavit, my lordship.
I have an instruction that some document is yet to be obtained.
let us give them the last chance,
Please, my lordship.
subject to cost on the next date if they don't file affidavit.
Please, my lordship.
Okay?
Yep.
We'll recover your expenses
Not
on the next day.
Please, my lord.
Item,
1,
One.
item 1.
Mr. So-and-so makes a mention on behalf of Mr. So-and-so. The learned counsel for the respondent
Respond.
and seeks adjournment of the case for 2 weeks for filing affidavit in opposition.
My lordship, kindly pick some 29th, my lordship.
Stop. On the next date fix. If no affidavit is filed, this court makes it clear that cost shall be imposed on the respondent. Listed on
29th of this month, my lordship.
29 of
This month, November.
November, listed on 29/11/2023. Yes,
Obliged.
For motion. Item number 35.
Please,
where's the impugn orders?
impugn orders is your lordship. 40-45, your lordship. Page 40-45, annexure 3.
Page 45.
Yes, your lordship.
Then, what is this?
Your lordship. First impugn is approval for detention under section 3, 1 and 2 of NSA.
This is a proposal to detain the.
Yes.
Continue.
Your
Okay.
lordship, my
The next,
next then it comes, your lordship, that page
46.
46, your lordship.
What is
that,
this?
I should be detained
It is
is up to 30/11/2020.
for the initial period of 3 months with effect from the date of the till Okay, then next.
Then next, your lordship, I submitted on the representation.
Uh,
And my representation is not acceded to by the page 55, annexure 6. And then page 56 is the wireless message by central government on the similar line.
This is from Minister of Home Affairs,
Yes, your lordship.
New Delhi to the state government.
Yes. Now, your lordship, I am having very limited this point here, yeah, that sponsoring authority, your lordship, have opined that there is every possibility of release me on bail. And number two, the detaining authority, your lordship, have not, there is not any subjective satisfaction, your lordship. Detaining,
That we will consider while deciding on matter.
yes, but here, your lordship, that nothing has been recovered from my possession. Then I have been implicated by.
Sir. P.B. Paul. The learned counsel for the petitioner. So, the petitioner is the wife of the detainee, namely Michael Yanton. The petition has been filed under Article 226 of the Constitution of India. Seeking for a direction to quash the letter dated 31/8/2023. Written by the Commissioner of Police and District Magistrate, Dimapur, Nagaland, proposing to detain the detainee under section 3 clause 2 of the NSA 1980, the order dated 11/9/2023 passed by the Chief Secretary to the Government of Nagaland, detaining the detainee at Central Jail, Dimapur, for an initial period of 3 months, with effect from the date of detention till 30/11/2023. The order dated 29/9/2023 passed by the Chief Secretary to the Government of Nagaland, rejecting the representation submitted by the detainee to revoke and set aside the detention order and the wireless message sent by the Ministry of Home Affairs, New Delhi, to the Special Secretary, Home Department, Political Branch, Government of Nagaland, Kohima, conveying that the representation submitted by the detainee has been rejected. Stop. New para. Issue notice to the respondents, returnable within 4 weeks. Mr. E. Tiba appears on behalf of the respondent number 1, 2, 3, 4. 1, 2, 3, and 4. And therefore, no formal notice need be issued. The learned counsel for the petitioner shall have also requisite copies of the writ petition
In course of the day.
to the learned government advocate in course of the day. Stop.
For 5.
Is Mr. E. Tipapong, learned government advocate, represents the respondent number 1, 2, 3, and 4, and Mr. Yangarwati, the learned CGC, represents the respondent number 5. Therefore, okay, no formal notice need be issued to the said respondents. The learned counsel for the petitioner shall however serve requisite copies of the writ petition to the learned counsel for the respondents in the course of the day, listed accordingly.
Item number 36.
Yes, Mr. Joshua.
May it please your lordships. Lordships, I am challenging the judgment and order dated 6/10/2023 passed by the learned single judge in WPC number 77 of 2023.
Okay,
My lord, the main points here, number 1 is that by filing the preliminary objection, the appellant was the respondent number 5 before a learned single bench.
you were the respondent number 5.
Yes, lordship.
You were the respondent.
I filed a preliminary objection. On hearing the preliminary objection, even if the preliminary objection is rejected, an opportunity should have been given to the respondent number 5 to file a proper affidavit against the petition filed. But it was prematurely disposed of.
You were not given the opportunity.
No opportunity was given to me to file the affidavit in opposition. Number 2, lordship, while gathering the documents, lordship, the preliminary objection was on the ground of the petitioner being overaged. He was more than 37 years of age when he approached his honorable court. And by the time he applied for the post also, he was more than 36 years. Now, lordship, there was some notifications, the office memorandums issued by the state of Nagaland to condone the age as a one-time measure relaxation during the time of COVID. So that was there, no doubt, lordship, but still he was overaged, and in the petitioner's petition also, he has not asked for reinforcing the one-time relaxation. That has already expired by the time he approached his own court. So without any prayer, lordship, the petition was filed. Hence, a preliminary objection was raised. Now, by the preliminary objection, the petition has been disposed. In the course of searching for the documents, the respondent number 5, before the learned single bench representative appellant, also chanced upon the documents, the school documents of the petitioner who is respondent number 1 before this appellate court. It is found that he was actually born in 1983 and not 85 as claimed by the petitioner lordship. And those documents, since the opportunity was not given to the appellant to produce the same before a learned single bench, by this appeal, lordship, some additional documents have also been annexed as per the provisions under the CPC, lordship. And I'm also asking for the interim protection
Whether
by
you are still in service.
lordship.
Whether you are still in service,
Yes, I'm still in service, lordship.
Mr. Joshua, learned counsel for the appellant. The present appeal has been filed, challenging the judgment and order dated 6/10/2023,
My lord.
passed by the learned single judge in WPC 77/2023. Stop. Admit the appeal for hearing. Issue notice to the respondents, returnable within 4 weeks. Anyone appearing
For the state.
for the state? Mr. You are appearing. Moim Chin, the learned senior government advocate, appears for the respondent number 1 to 4, correct? 1 to 4.
2 and 3, lordship. 2 to 4, lordship. 2 to 4.
Respondent number 1 is chief secretary.
This is performer respondent 2, 3, and 4. The state is a performer respondent, lordship. They are the performer respondents.
Okay. Appeals for the respondent number 2, 3, and 4. Therefore, no formal notice need be issued. The learned counsel for the appellant shall however take steps for service of notice. However, shall however take steps for serving the requisite copies of the appeal petition to the learned government advocate when
In the course of the day, Lordship.
in the course of the day. Stop. Insofar as the respondent number 1 is concerned, the learned counsel for the appellant shall take steps for service of notice upon the state respondents, by a registered post with AD within a period of
3 days, Lordship.
3 days,
My Lord.
listed after 4 weeks. Stop. In the interim, after hearing the learned counsel for the appellant, the judgment and order dated 6/10/2023
My Lord.
passed by the learned single judge in WPC 77/2023 shall remain suspended till further orders. Okay.
Oblige, your Lordships.
For admission, item number 6.
What is the matter?
Your Lordship. To this PIL, a series of authorities that has to be in place, like the State Mental Health Authority and State Mental Health Review Boards were raised because these were not been appointed,
Yes,
Lordship.
Mr. Moore,
However,
yes,
Lordship,
last-
during the course of the hearings, Lordship, they have made some progress. So with that, this court has also observed that the prayers of this petitioner was substantially been complied with and served. However, there has been one, this court has observed that White Order 26/10 of 2022, that the Nagaland State Mental Health Rules 2022 has to be notified in the official gazette. Unless that rule is notified, the act cannot be
Correct.
effectively implemented, Lordship. So since 26 October 2022, this court has granted time to the state to publish the same, Lordships, but till date, they haven't done that.
Mr. Moore Imchen,
Yes.
what is taking the state
Your
scope?
Lordship,
Ah,
we have done all the things.
I know.
Now, we have the provision of the mental health role provide. That it has to be conquered by the central government. So we have said it. Lordship, you will find my additional evidence.
Last time also you have made that submission that you had sent it.
We have sent it.
You have sent it.
We have sent it.
Why don't you take steps with the central government?
No, once it is come, it has to be done. Limited prayer of the petitioner in this bail is to establish the mental health role. We have done it. We have done it. Now, as per the provisions of the law.
Is it, ma'am, is it correct that the rules has to have the concurrence of the central government?
Lordship, yes, it needs approval of the central government as per section 121, clause 2 of the act. So Lordship, if that is the case, if they're saying that they have submitted for approval, if that is the case, then the state may be directed to expedite in following up. Because if the rule is already prepared, then there's no, I don't understand why there should be.
Mr. Moore, are you completely helpless?
No, I'm not helpless.
To
Your
request
Lordship.
the central government to expedite?
I have no hand over the central government. We have seen it.
No, you can at least request, you can send a reminder letter or something of that sort.
I have no hand over the central government. We have seen it.
You may have no hand, but at least I think you can take steps requesting the central government to expedite the matter.
since the issue is sub judice before the court.
Lordship.
Your lordship, the limited prayer is the establishment of the mental health laws in the state of Nagaland. We have done that. I have no hand there in the central government. We have sent that. We have done that. So this BL can be closed.
Without the notification of the rules.
No, once it is appropriate, we'll do it. We'll do it. We have framed the rules. We have framed the rules. What all formalities we are following? Because access.
You at least ask the officer concerned to remind the central government to expedite the matter. At least that can be done, because actually this is in public interest,
Correct.
not in the interest of any individual. So you can at least ask the officer concerned to send at least a reminder letter to the central government to expedite the matter. Okay. We adjourn the matter on that line.
Lordship, yes.
Mr. MS Nito Koza, the learned counsel for the petitioner, and Mohammed, the learned senior government advocate for the state respondents. Where is your affidavit? In your affidavit, you have stated that?
Yes.
Yes. What is your affidavit dated? Is it 20 October?
Yes, lordship.
Where have you stated that? In which paragraph?
It was sent on 1st September 2023.
Where have you stated, Mr. Moore? Which paragraph?
No, your lordship will file it the annexure.
Oh,
Last annexure.
annexure? Page?
The last page of my additional evidence.
Where have you stated that?
The lordships, please see.
Page?
3, paragraph 2.
Page
Page 3.
of your affidavit?
Yeah.
No, I don't find anything. Page 3, which paragraph you want to read?
Additional affidavit, your lordship.
Additional affidavit. Oh. Okay, okay, okay. Just wait, just wait. 11 October 2023. Is that the affidavit you're referring?
Correct.
This
Your
is,
Lord.
no, this is affidavit in opposition.
No, let's find the additional affidavit.
Take off. Additional affidavit. There isn't. No, this is affidavit in opposition. Is it affidavit in opposition or additional affidavit?
Affidavit in opposition filed for and on behalf of respondent number 1 and 2, as per the direction of this honorable court,
Affidavit, yes.
order dated 20/09/2023.
It is not additional affidavit. Are you seeing your file?
Yes. It has to be in the form of the affidavit in opposition. because
But you
the
have
query has
actually
been
submitted
raised by
in the form of affidavit in opposition. Whose fault?
Query has been raised. Query has been raised by this honorable court.
I know. Query has been raised,
Correct.
but you have filed it in the form of affidavit in opposition. I know the query raised by this court.
Correct. Your Lordship. But no, we have done that, your lordship.
This is
You
really
will
difficult.
find in the last page. The communication letter that we have sent to the Ministry of Health and Family Welfare, Karnataka, India.
This is framed under which rules? Ma'am? Under which rules?
Lordship stand Mental Health Care Act, Lordship.
Mental health care.
So Nagaland State Mental Health Rules, Lordship.
And this rule is framed by giving effect to which section?
Lordship, for the whole act, Lordship. Every state has been given the liberty to frame their own rules, Lordship.
So what is the Nagaland? What should be the title? Nagaland state rules. Here, draft state mental health rules.
Lordship, as per the submissions, it was recorded as the Nagaland State Mental Health Rules 2022, Lordship.
State mental health rules.
Yes, Nagaland State Mental Health Rules 2022. So going by records placed by this by the state before this honorable court, cabinet approval has also been received, Lordship, for the rules.
Okay. Mr. MS Mitokoza, the learned counsel for the petitioner, and Mr. Moa Imchin, the learned senior government advocate for the state respondents. Mr. Moa Imchin, the learned senior government advocate, referring to the affidavit dated 11/10/2023 at page 7, submits that the state government has submitted the draft state mental health care rules framed by the state of Nagaland under the Mental Health Care Act 2017 to the Ministry of Health and Family Welfare for approval. And the same is still, and the same is awaited as of date. The state respondents shall file a reminder letter to the Ministry of Health and Family Welfare to expedite the approval of the state mental health care rules at the earliest date possible. Listed after 3 weeks.
This will come up after 4 weeks.
After
4 weeks.
4 weeks. But you please take steps. You please take steps. Don't let the order passed by us be the last. After that, you pursue. Kindly pursue the matter.
We'll pursue.
With the central government, okay? Keeping in mind that this is in public interest. Correct. Okay. Listed after 4 weeks.
Lordships. Obliged.
For orders, item number 14.
May I please,
Yes, ma'am.
Lordships. Lordships, on the last court order, this court has directed the registry to prepare the paperwork.
Oh.
And till now, it's not.
Till
prepared.
now, paper book is not ready.
Yes, Lordship.
By which order?
27/9/2023.
27. What's more your fault?
Complainant also.
Okay. By the order dated 27/9/2023, registry was directed to prepare the paper books and to furnish the same to the parties. Stop. It is submitted by the learned counsel for the parties that the paper books have not been served to them as of date. Stop. Registry to take steps for preparation of the paper books as ordered by this court on 27/9/2023, listed after 3 weeks.
Obliged, Lordship.
Item number 15.
May it please the
Yes.
Lordship. Actually, my lords, this is an interlocutory application for condoning a delay of 19 days, my lords, which has occasioned in filing
Whether the notice has been served,
filing the connected report. My lords, although, my lords,
whether the notice has been served.
the steps were taken twice, my lords, as per my lord's last order also. Steps were
Let's see,
taken.
let's see the last order.
Yes, my lords.
Have you filed affidavit?
Affidavit has also been filed.
Where's your affidavit?
Affidavit is on record, my lords.
Is it 31 October 2023?
Yes, my lord.
Correspondent number 1, 2, and 3. Mr. So-and-so. Learned counsel for the applicant. and Mr. So-and-so. Learned government advocate for the state respondent number. You are representing
On behalf of V Supreme.
4-5,
Yes.
4-5. Four and five. 1, 2, 3. Have you taken steps on respondent number 7 and 8 also?
No, 7,
Because
8,
inadvertently, this order has left out this.
yes. No, 7 and 8, the learned CGSE appears, my lord, what I've been instructed. YP Gupta. The CGSE appears for 7 and 8, my lord.
Okay. None appears for the respondent number 7 and 8. So, by the order dated 11/10/2023. This court had directed the appellant to take fresh steps for service of notice upon the respondent number 1, 2, 3, and 6 by a registered post with AD and to file affidavit to that effect. Stop. The applicant has taken steps, has accordingly taken steps, and has filed the affidavit dated 31/10/2023, stating service of notice. Stop. Notice upon respondent number 1, 2, 3, and 6 is therefore deemed served. The waiver. I think that's still a bit. And has ma'am, and has filed affidavit to that effect. Correct? Stop. Cancel this. Office note dated 30/10/2023 shows that return service report still awaited. So. Where have you explained the delay? Which para?
My lord, the delay has been explained in paragraph numbers, my lord, 2, 4, and 5.
2, 4, and 5.
2, 4, and 5, my lord. The two grounds, my lord. First, the applicants, my lord, they are based in Delhi and Mumbai. Some delay had occasion in filing preferring the appeal. And secondly, during that period of time, my lords, there were rampant landslides, my lords, in the Dimapur Kohima highway. Therefore, the advocate could
Just
not.
wait, just wait.
I'm so sorry.
The present application has been filed under Section 5 of the Limitation Act 1963, praying to condone the delay of 19 days in filing the connected appeal against the judgment and order dated 2/6/2023, passed by team WPC number 128/2020. Stop. The grounds explaining the delay has been set out in paragraph 2,
4 and 5, my lord.
4 and 5 of the application. Stop. On perusal of the same, we are satisfied that the applicant has satisfactorily explained the delay. Accordingly, the delay of 19 days is condoned. Petitions is disposed. Okay.
My lords, the writ appeal would be numbered, my lords. And a date may kindly be fixed, my lords, will come from out.
In writ appeal. Heard, Mr. So-and-so. The learned counsel for the appellant. The appeal is admitted to be heard. Listed on. Listed after a week, listed after 4 weeks. The learned counsel for the petitioner, appellant, shall take steps no. The appeal is admitted to be heard, correct? Issue notice. Stop. To the issue notice to the respondents. Since Mr. So-and-so, the learned government advocate, appears on behalf of the respondent number
4 and 5, my lords.
4 and 5. No formal notice need be issued. The learned counsel for the appellant shall however serve the requisite copies of the writ appeal to the learned state council when?
Yes.
When?
During the course of the day. my
In the
lords.
course of the day.
Well, 7 and 8 is also represented, my lords, by the CGSE, my lords. Respondent number 7 and 8. So no formal steps are required. 7 and 8.
That was in the IA. That was in the IA. You texted it. Insofar as respondent number 1, 2, 3,
We serve it on the CGSE, my lords.
7 and 8. The notice, stop, the notice upon the respondent numbers 7 and 8, correct?
Yes, my lords.
Shall be served on
CGSE.
the learned CGSC within
2 days, my lords.
within a period of 2 days from today.
It's one request, my lords, kindly. My lord, for respondent number 1, 2, 3, we'll take steps by registered post, and lordship may also allow us to publish it on papers, my lord, because otherwise it's very
Next,
difficult.
insofar as the respondent
1,
number
2,
1, 2, and 3 is a concern.
And even 6 miles for that matter, the municipal corporation.
1, 2, 3, and 6 a concern. The appellant shall take steps for service of notice upon the said respondents by registered post with AD within a period of
3 days, my lords.
3 days within a period of 3 days from today.
And in addition, my lords, we'll also publish it on papers, my lords, substituted service.
Next, that will be next. Not going to be.
My lords, deeply obliged. Very good.
For hearing, item number 16.
Yes, Mr. Jimomi.
I am the respondent here, my lord. The appellant is the NIA.
This appeal is filed for cancellation of the bail.
Please. My lordship, this, can you take up the item number 17 first, my lordship? This is the two appeals are club matters. One.
Different.
Item
Different.
number 17, my lordship.
Different appeals.
Different appeals, it is same matter, it is a common order. This is the item number 17 is concerned to A1, my lordship, this is the most serious allegation against him.
17.
17.
Same case.
Same case, man.
Two accused.
So two appeals, that is the 16 and 17. See, 17 to be taken up first, my lordship.
It was the 17. Which is the impugned order?
My lordship, impugned order date is the 13th June 2022, my lordship. That is in the page number 22. Annexure 1, page number 22, my lordship. Twenty-two. Let's say here in parent court has considered two IAs. First IA is filed by the this accused number A1, that is IA number 34 1, 30 my lordship, 39 my lordship. That is the IA filed by the accused number.
Please take this one.
My lordship, first IA is filed by the accused number 1, that is the IA number 39 my lordship. The second IA is filed by the accused number A4, that is concerned to
This IA 39 is by accused.
A1, my lordship. That is
And
item
this
number
41 by.
filed by A4, my lordship. My lordship, come to the para number 6 of the impugned order, my lordship. That is a 25 page, my lordship, para number 6 of the impugned order. My lordship, may I read? I have considered the above the rival submission advanced by the land council for the parties. A perusal of the records shows that charge sheet was received this court on 29/12/2020. Cognizance was taken on 18/1/2021 and charges were framed on 6/5/2022 and trial of the case has fixed for 17/6/22. Be that as it may, to First, their submissions and land council further relied upon the same case laws will be briefly looked into the discussion. My lordship, trial court overlooking the problem.
What is the stage of the case?
My lordship, under the trial.
At what
progress-
stage?
Trial
Evidence.
Evidence, my lordship. This court, after framing of the charge.
Is the respondent appearing in the trial?
Yes, my lordship.
Mr. Jimami, is it in the stage of a prosecution evidence?
Yes, my lord.
Prosecution evidence?
Yes, my lord. There are 105 witnesses. And so far from the date of framing of the charge, which my lord, this prosecutor has.
5 are examined, my lordship.
Only 5 have been examined so far, out of 105 witnesses.
Okay, 6 continue.
My
Your
lordship.
para 6.
Para 6 is, my lordship, is the trial court after framing of the charge immediately has date of before that recording of evidence. This court has, trial court has passed the order and granted the bail to the second person, my lordship.
Read the para 6.
My lordship, para 6. On perusal of the record shows that charge sheet was received on this court on 29/12/2020. Cognizance taken on 18/1/2021. Charges was framed on 6/5/2022. Trial of the case is fixed on 17/6/22. In between, bail was granted to this respondent, my lordship. Before presenting of the prosecution by any witness one, my lordship. My lordship, in the impugned order, my lordship, come to para number 22, my lordship. The court has take the view. Para number 22, my lordship. Page number 27. This court has taken the view that when there is a delay in the trial.
Read your para 6. Don't jump here and there. Read your para 6. Let's see what judgment has been passed. From para 6, read.
My lordship, may I read? On perusal of the case records show that charge sheet was received on this court on 29/12/2020 and cognizance taken on 18/1/2021. Charges was framed on 6/5/2022 and trial of the case is fixed on 17/6/22. Be that as it is made to better their submissions, the land councils had relied upon some case laws which will be briefly looked into and discussed. My lordship, case laws, that is the main ratio is.
Read down.
Don't
explain.
The land council has relied upon the Union of India versus KN Azib 21/3 SCC 731 to show that the right of the speedy trial would be overrid. The bar has provided under section 43D5 of the UAP Act. It was held that in that judgment, my lordship, the paras is quoted. It is 18. It is clear that to have the presence of the statutory restrictions like section 43D5 of the UAP Act per se does not ask the ability of the constitutional court to grant the bail on the grounds of violation of the part 3 of the Constitution. Indeed, both the restrictions under the statute as well as the powers exercisable under the constitutional jurisdiction can be well harmonized, and whereas at the commencement of the proceeding, court are expected to appreciate the legislative policy against the grant of bail, but the right rigorous of such provisions will melt down where there is no likelihood of the trial being completed within the reasonable time and period of incarnation already undergone as exceed as a substantial part of prescribed sentence. Such an approach would be safeguard against the possibility of the provisions like 43 D5 of UAP Act being used as sole metric for the denial of the bail for wholesale breach of the constitutional right to the speedy trial. Para 19 adverting to the case at hand, we are conscious of the fact that the charges leveled against the respondent are grave and serious threat society harmony. Had it has been case threshold, we would have rightly turned down the respondent's prayer. However, keeping in the mind that the length of the period spent by him in the custody and the likelihood of the trial being completed any time soon, the High Court appears to have been left with no other option except to grant bail. An attempt has been made to strike a balance between the appellant right to lead the evidence of its choice and establish the charges behind any doubt, and simultaneously and respondents' rights guaranteed under the part 3 of the Constitution have been well protected. Yet another reason which to enlarge the respondent on bail is that Section 43 D5 of UAP is comparatively less stringent than the Section 37 of the NDPS Act and NDPS. Unlike the NDPS, where the competent court need to be satisfied that prima facie the accused is not guilty and that he is unlikely to commit another offense while on bail. There is no such condition under the UAP Act. Instead, Section 43 D5 of UAPA merely previous another possible ground for the competent court to refuse bail, in addition to the well-settled consideration like gravity of offenses, possibility of tampering with evidence, influence of witnesses, or chance of the accused evading the trial by accusation, etc. The Land Council for relied upon the Angela Arish versus State of Maharashtra 2023 SC73 to show that notwithstanding Section 43 UAP Act, bail can be granted even in case serious offenses. This was under Section 10, 13, 17, 18, 18A, 18, 20, 21, 30, 39, 42 2 of UAP, along with Section 387, 419, 465, 464, 68, 471, and 120B of IPC. Taking note of 5 years incarceration and trial yet to be commenced with over the 200 witnesses proposed to be examined, the appellant was enlarged on bail and court held as under. Undoubtedly, the charges are serious, but seriousness of the charges will have to be balanced with the certain other facts like period of custody and supper and the likely period within such trial can be expected to be completed. Next, similarly, in Sagar Tatyaram Gauhati versus State of Maharashtra 2023 SCC 725, which was also relied upon by the Land Council, the Honorable Supreme Court, while discussing the scope and power of the court to grant bail in serious offences, and observed that the serious charges against accused will serve to be balanced with the likely period within the trial can be accepted to be completed, held as under. We are informed today that till date, the only one witness has been examined, that who is examination is also not. However, the prosecution proposed to be examined 147 witnesses. The accused appellant have been in custody close to 4 years. In the above circumstances, we are of view that the accused appellant who should be granted the privilege of bail. Next judgment, my lords. Sanjay Chandra versus CBA 2012 1 SCC 40, it observed that in our seriousness of the charges is no doubt one of the relevant consideration while considering the bail application, but that it is not the only the test or factor. Otherwise, if former is only the test, we would not be balancing the constitutional right, but rather the recalibration of the scales of the justice. Para 20. This court has taken the view that when there is a delay in the trial, bail should be granted to the accused minorship. Thus, considering of the fact of the facts, accused persons are custody close to 2 years without trial having been to the commenced, and with 105 witness proposed to be examined, there is no likelihood of trial being completed within a reasonable time with the facts and instant case is corresponding to the facts of the case lie above discussed, I am inclined to enlarge the accused person on bail. Accordingly, in view of the aforesaid incident, applications allowed and accused Railing Nabe and Jingshang Munyo alias Jingshanggo are hereby allowed to go on bail and 1 lakh each and 2 local surety amount following conditions. Accused shall not be leave the jurisdiction this court without prior permission of this court. The accused person shall not directly, indirectly make any individual that promise to the person acquainted with the facts of the case so as to discuss him to disclose the fact, and the court or authority and the accused persons shall remain present before the dates fixed for the hearing of the case. With the above observation and direction, both bail applications are stand disposed and occurred. This is the order, my lordship. My lordship.
So that we will be able to know whether as to the condition of the use, how the contract of the communication of
Mr.
Yes, ma'am.
I think we intend calling the records, scan copy of the records to see how the trial is progressed.
Very well.
To see whether the accused, the respondents are regularly attending the court.
That we are. In
So
fact,
let us see the record so that at least to pass any order,
Right.
let us take all these circumstances into consideration.
Yes, ma'am.
Okay.
We have never failed appearing before. the
Yes,
court.
it's a,
Yes, ma'am.
in fact, to your advantage.
Yes, ma'am. And in fact, no such ground is taken in this application for cancellation.
No, that is for our satisfaction.
My lordship, our ground is only the trial court is not consider the statutory provision as well as the ratio laid down in the Najib versus Union of India. That Najib versus
That,
my lordship, only constitutional court can.
Mr. Leonard Public Prosecutor, we will consider all this. We will consider all this, but we would also like to call for the records.
Please,
Scan copies of the
please,
records.
call
So that we will not disturb the proceedings.
without disturbing the trial of. the
Yes,
court.
yes. I heard Mr. So-and-so, Leonard Counsel for the appellant. Leonard,
Senior PP NIA.
Senior PP NIA for the appellant. And Mr. H. Momi, the Leonard Counsel for the respondents.
Yes, madam. In both the appeals.
For the respondents.
In another one matter, the other bench.
Yes.
principal bench, it is already cancelled the bail, concerned to A7, the wipe of his accused number A1, my lordship.
In the course of hearing the matter, we deemed it proper to call for the scanned copies of the proceedings of the case, which is in progress before
The Learned Special Judge NIA Dimapur.
the learned special judge,
Yes, ma'am.
Special set Dimapur.
NIA
Dimapur.
Dimapur, Nagaland. The learned special judge, NIA Dimapur, Nagaland, is accordingly directed to submit the scanned copies of the proceedings of case number
Case number.
RC number
RC2 of
2 up 20.
RC2 of 2020.
RC2 of
2020.
2022.
2020 minutes.
2020. Within a period of
2 weeks, madam.
2 weeks from today.
My lordship, even call for the evidence submitted to the court, that is the statements, that is also stand copy required for
No.
producing whether it is.
I think
Prima facie to be looked into, my lordship. That copies.
you have examined only 5 witnesses.
No, my lordship, I am calling for the what the prosecution has submitted statement of. What the prosecution has submitted the statement of witnesses before the court, that copies may be called for scan copies, my lordship.
The evidence you mean? You mean the evidence?
No,
That is the
no,
prosecution
he-
supply the material evidence.
No, the evidence which the
Along
prosecutor
with
has
the
supplied to the court.
Along with charge sheet.
Statements of the witnesses recorded by the prosecution, the NIA during the process of investigation. That's what he means.
That may not be relevant.
May not say that is the Jarur Rahman, the total judgment. The court cannot be looking.
No, no, we just want to see how the progress, how the trial is in progress. That's all.
That is also looking during whether it is a prima facie.
Because if we are to confine ourselves to that,
Please,
it may not,
please.
Yes, my lord.
it may not be in the interest.
Watali's judgment has been revisited on many times, on many occasions. by the Honorable
Last
Supreme.
judgment, this other bench also passed in the other accused person challenging before principal bench.
Yes.
In that judgment also held the prima facie is required to be
Yes,
looked
no,
into.
but after
Therefore,
this,
my request has to
after
be.
this, my lord,
Lordship kindly
after
to-
this, even in Najib's case, Watali's case has been revisited. Now, after Najib's case, there has been more judgments by the Honorable Supreme Court.
Very good.
Watali's judgment has actually been revisited on many occasions. The other NIA is the prosecutor, the NIA is relying only on Watali's judgment. And it is quite erroneous, even I may say so. With all due respect to my learned friend.
Yes.
To rely only on
That-
Watali's
that,
judgment.
we will consider during the hearing. We will
Please, ma'am.
consider everything
Please.
during the hearing. Okay. What was the last line?
To submit the scanned copies of the proceedings RC2 of 2020 within a period of 2 weeks from today.
Okay, within a period of 2 weeks from today, listed on
15th, 15th,
15th of
this month is a Wednesday. 2 weeks, exactly 2.
Will it be possible for the learned?
I think the MOPO should be possible. If not, we can again extend, we can try it actually on the 15th. Because the lordship during the end of the month, again, I have to be out of the station for my children's educational purposes. That's a problem.
Okay, listed again on 15th.
Yes.
May Lordship.
Listed again on 15/11/2023. Yes, same order
Yes.
in this also.
What should I?
Computer section, court 1/1.